Hello viewers, today's topic is retracted confession statement during the examinations and under section 342 of the Code of the Criminal Procedure. And what is retract confession statement and how to retract confession statement or when it will be permitted before the code retract confession statement, and I am going to discuss about retracted confession statement during examination under section 342 of the Code of the Criminal Procedure. Section 164 confession statement, the Code of the Criminal Procedure, and section 342 another confession statement, or there is the chance to give the statement by the accused before honorable court, and there is the chance to submit on behalf of the accused the corroborative evidence. This is the section 342 of the Code of the Criminal Procedure 1898. Actually, murder case, I am going to discuss about another murder case. Fact of the case, victim murdered by the accused, and there is two victims, and this is and death by the accused. Actually, arrested the thank you Paritosh Roy, Advocate Paritosh Roy, thank you from Dinasport, thank you very much, my younger brother and my nearest brother, thank you very much, and thank you very much everyone to viewers and who are joined the live sessions and share my lecture with others, and I would like to appreciate my heartfelt gratitude and to all my viewers. Thank you very much. Murder case, actually section 302 and 34 of the Penal Code 1860. How to do or act done by the accused the offense having planned knowledge, pre-plan, or after doing the act there is the more facilities or benefited doing act or offense by on behalf of the accused petitioners. First time given the confession statement section 164 of the Code of the Criminal Procedure before the court, and before taking the confession statement from the accused petitioner, and first time alert, and it will be voluntarily and willingly from the accused petitioners, and there is no chance to torture by torturing, mental or inducement or any other bad sense, and there is no chance to send the accused in police custody after given or getting or taking confession statement section 164 the Code of the Criminal Procedure 1898. Actually, after giving the confession statement and there is the chance to retract, and after actually started the trial that the stage of the Shafai Shakhi under section 342 342 of the Code of the Criminal Procedure and apply for retracted confession statement, court decide that and find out the taking the confession statement from the accused and with voluntarily and willingly, and there is no options by torturing mental or physical, and to send the accused in police custody. But this confession statement, given the confession statement, it will be or is true and genuine before the court. Actually, after long durations, given the confession statement, after long durations, there is no chance it will be not permitted before the court as a applications of retracted confession statement, because confession statement are granted before the court with voluntarily and willingly, and there is no options by torturing mental or physical or inducement to the accused. And before taking the confession statement before the court, said that I am not foolish and you are in safe zone and there is no chance to torture, inducement, and never chance after getting or taking the confession statement under section 164 of the Code of the Criminal Procedure to send again in police custody. Durations or maintain the decorum of that the confession statement true and genuine before the court, and it will be applicable or apply against the accused petitioners. For the purpose of the accused petitioners and the convicted, Honorable Court convicted the accused death sentence, and it will be identified with the relevant documents which is submitted before the court by the prosecutions. It is very necessary and to chance to convict the accused petitioners for the purpose of the LA crime, because specific allegations identified with the by using or submitting the relevant documents before the court by prosecutions as liability burden of proof under section 101 of the Evidence Act 1872, and prosecutions has no chance to deny or never giving the answer which is the important and arising the questions before the court. Prosecution is bound to give the answer for the purpose of the arising questions before the court against the allegations, and it will be identified specific allegations before the court for the purpose of the submitting, for the purpose of the relevant documents, submitting relevant documents for the purpose of the case. I hope that my lecture will be clear, and please knock me and give your, please you can mention in comment box my sound is clear or not. I will try to be clear and my sound through my lecture, through my live sessions. Thank you very much. And stay with me and watching and listening me, and everybody is supporting me, and I would appreciate and heartfelt gratitude to all my viewers and my learned friends, senior and junior, who are connected and who are joining the live sessions and watching and listening me. Thank you very much. And this topic, retracted confession statement, under section 342 of the Code of the Criminal Procedure, but it will be taken before the court under section 164, confession statement before magistrate, but there is no option, there is more options to retract. It will be given for the purpose of the allegations by torturing police officer, but when started taking the confidence statement in the court, and the honorable court alert to the accused, and there is no chance and two options by torturing, inducement to you, and never sent again in police custody, because every or after before giving the confidence statement, the accused stay in fear, given confidence statement, and it will be never specified, and another sent in the police custody, he will be tortured by police. Actually, confidence statement section 164 and retracted confidence statement, judicial or extrajudicial, there is no matter, but it will be granted or not, because willingly and voluntarily given the confidence statement before the court and mentions that there is no chance by options zero torturing, and by torturing the or inducement to the accused, and voluntarily and willingly given the statement. This is the confidence statement under section 164 of the Code of the Criminal Procedure. Thank you very much, Shopik, Advocate Shopik. Thank you very much, from Kumula. I hope that this is the fact, or this is the topic, today's topic about retracted confidence statement. Confidence statement, there is the options by torturing, by any other way, and it will be harmful for the accused petitioners, and fairly given the confidence statement. But court believe that there is the pressurizing the accused by given the confidence statement, then there is a chance retracted confidence statement. But after given confidence statement, after long durations examinations under Article 342 of the Code of the Criminal Procedure, Shafai Shakhi, and the accused apply for retracted confidence statement, it will be judicial or extrajudicial, but court find out it will be voluntarily or willingly, and that is true before the court for the purpose of the allegations of the case against the accused petitioners, which is relevant. Actually, convicted the accused petitioners 14 years in condemned cell. The High Court divisions find out that already he was for 14 years in condemned cell. With justice, the converting the or change the death sentence to lifetime imprisonment, because with humanity and justice, because he was suffered for the purpose of the case and allegations against him and convicted the honorable court, and he was in condemned cell. And court decide that analysis the relevant documents and bringing allegations against the accused petitioner which is relevant or not, because prosecution submitting the relevant documents before court against the accused petitioners, it will be relevant when the supporting relevant documents and being guilty and convicted the accused petitioners against the for allegations of the case, but 14 years convicted the accused and he was 14 years in condemned cell. This is the harmful and sufferer person at court, high court divisions change or maintain or converting the death sentence to lifetime imprisonment. I hope that my lecture will be clear and I will try to find out the specific allegations and for the purpose of the case and which is arising allegations by the prosecutions against the accused petitioners and submitting relevant documents. Actually, court has the options and find out the relevant documents, and it will be find out that being guilty or not the accused petition for the purpose of the alleged crime. Advocate Alamgir Khan, thank you very much. Actually, retract the anytime there is no chance for options and for retracted confession statement during the examinations under section 342 of the Code of the Criminal Procedure 1898, because given confession statement there is long time. After long time he complained given the confession statement is wrongly taken from him, because when he was giving the confession statement he was not voluntarily given confession statement willingly, but court find out that the confession statement true or not true or genuine, it will be find out that is the voluntarily or willingly given the confession statement before the court, because before taking the confession statement from the accused and court said that on alarm there is no options to torture or not options to send again in police custody, and it will be given by you, it is used or applicable against you, because you are knowing I am not police, I am court, honorable court, and you freely and you have freedom to give the confession statement who is relevant or arising allegations is the specific allegations against you, it will be not or yes. Committed the sentence. The material from the material on record, it is found that the tribunal passed the judgment and order of convictions and the sentence date of the appellant on the appellant have been in condemned cell for more than 14 years, suffering he pangs of the death. In the circumstance, we are of the view that justice would be sufficiently meet the sentence of death is appellant to be committed to one of the imprisonment for life. Committed the sentence because this topic or this matter is very relevant, because already he was suffering 14 years in condemned cell, and for justice on behalf of the accused, the court find out the relevant documents or analysis through by relevant documents against the bringing allegations against the accused petitioners. Already 14 years gone in condemned cell, he was in condemned cell or he was staying in condemned cell. or 14 years, and more suffering person. And then the court decided and commuted the death sentence to imprisonment for life. This is the topic, today's topic, and this is the hour or my lecture. From the material on record, it appears to us the appellant made confession statement implicating themselves in committing the murder of the deceased victim Shakina and Will Sohel. The confession statement were made voluntarily. The judicial confession, which appears to be true and made voluntarily, can be sole basis of the conviction against it maker with further corroborative evidence. Corroborative evidence is supporting evidence. Actually, when the prepare for Shafai Shaki section 342 of the Code of the Criminal Prosecutions, the accused has options to submit relevant witness or corroborative witness even, and permitted the witness before the court, and they can give statement before or the court. But before giving the name of the corroborative witness in the list, the accused have to maintain about the witness, otherwise given statement or taking statement from the witness, it will be harmful or applicable against him. Before giving the list of corroborated witness under section 342 of the Code of the Criminal Procedure, be careful. Given the list of the witness, the name of the witness prefer you, but it will be applicable against you, or this case, those witness will be hostile. You are harmful for the purpose of taking the statement by your witness. But first time you giving the confession statement, but when the investigation officer submit police report, and then the honorable court sent or transferred the case to trial court, started trial, and when the coming stage of the Shafai Shaki article section 342, the accused have decided or remembered that given the confession statement, it will be applicable against me, and he or she is not get the justice from honorable court, then the option or remember that this is the chance and applicable for retract confession statement, that is not allowed before the court, because long time duration examination of under section 342 of the Code of the Criminal Procedure, because court identified that the taking the confession statement, it will be voluntarily and willingly, that will be true and genuine before the court by given the confession statement under section 164. because retracted confidence statement means previous statement are changed, because it will be never applicable against the accused petition. There is no option, and he was giving giving voluntarily and willingly confidence statement before the court, and before taking the confidence statement, the court alarmed him. There is no options by torturing or inducement. You freely, you willingly or voluntarily given the statement which is knowledgeable for you or to you. But after giving the confidence statement, this word, it will be applicable against you. This is positive side, you are benefited. Negative side, you are harmful, and options to get the justice, it will be not sufficient for you. And thank you very much, and to all viewers and my learned friends, senior and juniors, my colleague, everybody supporting and stay with me. And at midnight, and with your support, I hope that I do better. I will do better in my life than past, and continue. It is very great achievement for me, because I get you and your continued support. Thank you very much, and who are joined the live sessions and watching and listening me and my lecture, and who can share my lecture with others. This is the great achievement, and thank you very much. I would like to express my heart-left attitude to everyone. Gratitude to all person or to all viewers. And coming soon, bar council exam, and there is no enough time, and who are candidate for bar council exam, and be very serious and clearly study daily routine, and member of the Saral Academy, I always support or advise you, be careful and connected with Saral Academy, and some model test will be submitted and ready for your exam, trial exam, and be connected and call me. I hope that this model test will be support you and get the success in your life, being advocate in your life. And I hope that, and Saral Academy always support you and being advocate, and you will be bright, you will be future in our society. Thank you very much. I hope that this is the lecture, and this lecture will be helpful and for law students, and the law students or advocate who are practicing in lower court or high court divisions in the criminal side, because I feel that I am criminal lawyer and regular practitioner in high court divisions, Advocate Sharul, Supreme Court, Bangladesh. Thank you very much, and good night, and stay with me. This is my great opportunity. This is my great achievement, and I hope that next time and next topic I will come back and with live sessions, and I hope that you will be connected with me, that my live sessions. Thank you very much. Good night. Namaskar. we find no wrong or illegality at the finding of the High Court divisions to convict the appellants for murdering Shakina and Shoaib and sentencing them to death based on judicial confessions. Such the convictions and sentence passed by the High Court division in respect of the appellant does not suffer from any kind of legal infirmities. Thus, does not call for interference by High Court divisions. And retracted confidence statement during examinations under section 342 of the Code of Criminal Procedure, and we find the statement recording the magistrate after observing all legal formalities recorded the statement of the accused pleading appellant. Thus, we are not hesitant to accept the same as true and voluntarily in the case of the appellant retracted their confidence statement during examination under section 342 of the Code of Criminal Procedure. Actually, be prepared and giving the statement, confidence statement, it will be applicable against me. Remember that. Then you can give the confidence statement before the court. Because law is equal everyone, Article 27 of the Constitution law. And prosecution is bound and has liability to submit relevant documents, which is very relevant for the purpose of the case, because bringing allegations against the accused petitioners and by prosecutions has liability and with supplementary or relevant documents submitted before the court, because the court convicted the accused petitioners, identified the relevant documents which is connected for the purpose of the case. 164, 161 and recovery documents and forensic report MC and when happened or where happened and place of offense, time of offense and eyewitness, which will be very important and submitting or very necessary. And with eyewitness being guilty or convicted the accused petitioners by the honorable court, this is very necessary matter. But confession statement and another during examinations under Article 342 of the Code of the Criminal Procedure. Given confession statement, you agree that because you agree with voluntarily and there is no inducement for you by torturing any other person, police officer. But after a long time, you want to change your statement, confession statement, but you have to maintain necessary documents because you are not free when you was giving the confession statement and there is no options except another options without giving the confession statement. But court identified that when you was giving the confession statement under section 164 of the Code of the Criminal Procedure and identified voluntarily and willingly, and there is no options by torturing or inducement by police officer, and before taking the confession statement, court said that I am not police, I am honorable court, and no options and feel fear and torturing options never applicable, effective on you of you, and not sending you another in police custody. And you agree that you will agree that your confession statement section 164. But after a long time, why you can retracting you can retract the confess statement. There is no reason. You have to identify the specific reasons and necessary for retracting or retracted confess statement. But High Court divisions find out that convicted the person and he was agree with confess statement, but during the examinations under section 342 of the Code of the Criminal Procedure, and the accused apply for retracted confessions, there is no options, because voluntarily and willingly it is identified before the court. And convicted gets sentence, but the accused was sufferer for 14 years in condemned cell, and court decided that this is the sensitive and he was suffering long time and commuted the sentence, gets sentenced to imprisonment for life. This is the lecture, today's topic about retract confessor statement. Retract confess statement, it will be judicial or extrajudicial, doesn't matter, but you are voluntarily, you are giving confess statement with voluntarily and willingly. So thank you very much, and who are joined and who are staying with me and joining the live sessions and support with me. This is the great opportunity, and I hope that again thank you and express my heartfelt gratitude to all viewers and who can share my lecture with others. This is the great achievement in my life. And thank you very much. Good night. Thank you very much. Namaskar.